Good afternoon, Ms. Semenya.
Good afternoon, Chief Justice.
Are you well?
I'm well, Chief Justice, thank you.
What are your qualifications?
I did a B.Juris degree with the University of the North, now University of Limpopo.
Yes.
I started working as a prosecutor and I studied part-time. I obtained my LLB with UNISA.
Yes. And what have you been doing over the years which has prepared you for the position you're now applying for?
I started as a prosecutor in 1985 up to 1991. I was then appointed a district court magistrate up to 1991, from 1991, until 2013. I was then appointed a senior magistrate at Seshego, and then the following year I was appointed as the regional court magistrate. I started the sexual offences court at Mukerong.
At
Mukerong. Mukerong is a township 5 kilometers outside Mokopane.
Yes.
It was a sexual offences court, but I was doing the entire Waterberg area,
Yes.
comprising of Mokopane, Mukerong, Mohopong, Mudimolle, Bilabila, Lepalale, Northern, and Tabazimbi.
Yes. And you've acted as a judge?
Yes, I did, Chief Justice.
How did that prepare you for what you are applying for now?
My past experience. Are you referring to my past experience?
Your experience as a magistrate, as an acting judge, how have they capacitated you for what you're now applying for?
I think the best court that prepared me was the regional court, the sexual offences court.
Yes.
Because in that court, initially we didn't sentence. We were doing the trials and then transferring the matters to the High Court for sentence. And when they come back being confirmed and sentenced, you feel that you have done a good job.
Yes.
And also because you don't sleep there. You are in court from 9 o'clock up to 4. And after that, you'll rest for about one or 2 hours. You'll be writing judgments through the night so that you don't have many pending matters, pending judgments. Because if you don't write those judgments during the night, you'll be picking up more and more pending judgments. As a result, you won't cope.
Yes.
So I can say that court prepared me a lot, because when I started acting in the High Court, it was in 2014. I was given a secretary. When I arrived there, I told her that this is my first stint. I know nothing about the High Court, and you are going to be assisting me with certain things like where's the bathroom, where do I go, the tea room, and so forth. Then at the end, when I was leaving, she was assisting me to pack my things so that I can go back home. And she kept on exclaiming me, yeah, and I said, why are you doing so? And she said to me, are you sure that this is your first acting stint? And I said, yes, this is my first acting stint. And she said, and I asked her why, and she said to me, it is for the first time for me to have an acting judge who is her first stint, but she goes back home without any pending judgments. I had done all my judgments, and further she said to me that, and when you write your judgments and I take them to the senior judge, they come back, all of them, they only came back with very few mistakes and being spelling mistakes only. So I said to her that, yes, this is my first acting stint in the High Court, but remember that I've been writing judgments for many years.
Yes.
So I didn't find it much difficult to cope with the High Court.
Yes. JP?
Thank you, CJ. Ms. Semenya, during your acting stint in Gauteng, you managed to pen or to produce 2 reported judgments, 1 civil matter and 1 criminal matter. All are reported in the South African Law Report, correct?
That is correct, GP.
Now, in one of the reported matter, the civil matter, had to do with forfeiture of benefits arise of the marriage and community of properties, a divorce matter. Now, in that matter, you declared Section 9 of the Divorce Act unconstitutional by virtue of the fact that it introduced a guilt principle of substantial misconduct as an element of a forfeiture. And, is it correct that matter is now before the Constitutional Court for confirmation or otherwise?
Yes, I was doing it with a senior judge. And we said, we are saying we are having a guilt-free divorce system in our country. But at the same time, we are introducing guilt in terms of Section 9, because that section says that one can forfeit marital benefits if he can be found to be guilty. So we say the two doesn't marry. Guilt-free divorce system, and on the other hand, we say, yes, we can punish you if you are guilty. So we were saying that we find it to be unconstitutional, or to be, we said that section must either be amended so that that portion must be excluded, and or it must be dealt away with in its entirety.
The fact of the matter is that the matter is now before the Constitutional Court for confirmation or otherwise.
No, I am not aware of that.
Okay,
because what
for
we are saying that the parties can invite others, because there were other parties which were to be joined in that before it can go to the Constitutional Court. But what it did is to provoke a debate as far as that section is concerned, because I've seen many articles written about it thereafter.
Right. During your acting stint, you will recall that you handled a lot of matters with me, especially when you started acting in Limpopo. We did a lot of appeals together, both civil and criminal, even full court appeals. And at all times, I insisted that you write judgments.
Yes.
And you did write most of the judgment. Didn't you feel that you have been overworked in that stage?
I think, as I've already said, I'm used to that. I've been writing judgments and I've written many judgments, so it doesn't bother me. Writing judgments do not bother me at all. In fact, it enhances my work. And at times, like I say, I'm a magistrate. If those judgments are confirmed elsewhere, higher court, I become satisfied.
Again,
I'm not one of those magistrates who are afraid of taking their matters for appeal and so forth. It teaches me a lot.
Again, I've noticed that you were in a position to produce judgment within 30 days, in almost all of your matters.
I did, in almost all of them, yes.
Right.
Unless it is a very involved matter, which I must sit down, research, rethink, and so forth.
Right. You have also acted at our local division in Toando. Now, this is a semi-rural area where traditional norms are still being applied there. Did you feel accepted when they see a female judge in that situation, and how was the reception?
I never encountered any negativity. I worked well with them. I do not remember anyone's. I don't think anyone ever came to you to complain that I am not handling them well, because I always say, and I've taught myself because of my past, I've taught myself to say, here are the parties. To me, there are no senior counsel. There are parties before me. They are equal. I must treat them equal. All I'm interested in them is to hear what they want to bring before me and to apply the law to what they are bringing before me. If it favors a junior counsel, let it be. If the judgment must favor the senior counsel, let it be. But before me, I regard all of them as equal. I am only interested in what they will be bringing before me.
Yes, if you are appointed, you'll be the second female judge in Limpopo in a bench of, say, 9 judges. We only have one female who's my deputy. Now, what would you do to encourage other women to follow suit so that we can transform our bench to comply with the gender imperatives?
I remember, JP, that we are actually the first females to become magistrates and so forth. We were in the 80s. We were very few. I was the second in Limpopo, and I always say to them, if you want to go and act, feel free to do so, because but what I encounter from most of them is that they tell me that they are still raising their children, they will do them thereafter, and that they are scared. And I said, you must take it from us. We were the first, we paved the way for you people, because we started during those years where they will say, she's a woman, what do you think? What do you want here? And what was happening, I always discuss it with my other female colleagues when we were, with whom I started in the 80s. And we say the attitude was that of constructive dismissal, because they will overwork us, but we were saying to them, we are here and we are here to stay, you better make peace with yourself. So I always encourage them to say, people, it is work, you have been properly trained for it, you appear in court, you defend matters, you prosecute matters. Don't think of yourselves as women. Think of yourselves, yes, you are women, but you are legally qualified. You have been attending the same classes with them. So what makes you think that only men can do it and females won't do it? We have been there. I've been there for 30 years and I'm still there.
Thank you, Chief Justice.
MEC.
Thank you, Chief Justice. Mrs. Semenya, having practiced in Limpopo and lived in Limpopo for such a long time, obviously you are aware that Limpopo is predominantly rural, but as well there are several impediments that might not help our people to access justice system. And what is it that you think you will be able to do to make sure that we enhance access of those majority of people who are in the rural areas for them to be able to access the justice system? Obviously, we know that you have been able to do undertake awareness in several areas. You have been able to do community work, and therefore you will have that understanding in terms of what are the kind of challenges that are facing people in those rural areas, and what is it that you are bringing to that fore to make sure that you are able to enhance that access. Thanks.
You know, we always encountered those kind of challenges. Like I will talk about what my experiences are, because I believe that they work together in the same way in the High Court as well as in the other lower courts. For instance, you'll have parties who come from remote areas in the area where there will be only one transport that leaves that area at 6 o'clock in the morning, transport people to town, and it will leave town at 14 hours, which means if that party leaves, you haven't helped that party earlier, she's going to miss that transport back home. So what we are doing is that when I go to court in the morning, I normally go to court at about 10 minutes to 9 o'clock to do case flow before we can start with the court. What happens is we look at the cases that we are having. If some of them come from the remote areas in Limpopo, in our, like Gilead, Tombek. Tombek is at the border between Botswana and South Africa. So we help those people first. And thereafter, we can deal with those who are coming from around, who can foot it to their home, knowing that those others are now back home, they didn't miss their transport. So I think the same thing will happen in the High Court as far as members of the community are concerned. Because Limpopo High Court as well, it's a vast area. And as you say, it's a vast area which comprises of rural areas. So you look at your role, you help first those who come from far so that they don't have to miss their transport back home. Otherwise, you'll have to accommodate them somewhere so that they can sleep and go home the next day. As well as women, women with children. like when I was a district court magistrate, as I was saying, that we were treated in such a way that it appeared as if they wanted to do away with us. You will go to court at 9 o'clock, and in the criminal court, you'll preside there until tea time. When you break for tea, you find a queue of people waiting for you for help, members of the public, be it for maintenance, for estates, and if you don't help those people, if you leave them for that tea break and say, I'm going back to court because I'm in the criminal court, I cannot assist those who are doing maintenances and estates, there are other magistrates who can do that, then it means that the possibility is you will find them again when you come back at lunch. When you adjourn at lunch, you'll find them waiting there. And remember, it's a rural people. It will be widows in black. And as I say, she may be coming from the most remote area. So if you don't help her, she's in black, she misses her taxi back home, who's going to accommodate a widow in her house? So you prioritize them according to where they come from. You help them, they go away, you remain with local people. And I think as far as awareness is concerned, we have done enough, even though it will not be more than enough. They know they can report domestic violence, they know they can come and claim maintenance, and they know that they will be assisted.
Are you done, MEC?
Thank you, Chief Justice.
Thank you very much. Commissioner Singh?
Thank you very much, Chief Justice, and good afternoon, Semenya.
Good afternoon, Commissioner.
Just two issues that I would like to raise. I'm sure you've had a look at the comments that have been sent in, letters of support and etc.
Yes, I
There's
have.
one that comes from the Black Lawyers Association. And one is surprised to read, well, they say you were appointed as a prosecutor. The Black Lawyers Association is of the view that acting for a longer period would benefit her. At this stage, the Black Lawyers Association does not support her appointment. How would you react to this?
I saw it, I read it, and I reread it, but I failed to find reasons why they are saying so. It would have helped me if they say she needs further acting on this aspect so that I know where to improve. But as it is, I just read it again, and I don't know why they are saying so, because I have been presiding for over 25 years now in the both district court, regional court, and I also acted in the High Court. And as you heard our JP of Limpopo, he said, my first acting stint, I produced 2 reported judgments, both criminal and civil. So as to what area they are talking about, I do not know.
You haven't had an opportunity to engage with them on this?
No, I didn't. I didn't, Commissioner. Maybe I should have done that. I don't know.
Yeah.
Maybe they would have shed a light on what they are talking about there.
I'll leave that for now. There's another document we've been handed earlier on, which refers to a conviction where you were presiding of somebody convicted for attempted murder and violent rape, where the sentence was 2,000 Rand fine and a 5 years fully suspended sentence for a violent rape. Now, reading this, to us, it would seem that, a suspended sentence for 5 years for violent rape is not an appropriate sentence. However, we do not have the benefit of the facts of the case, etc. Can you just talk to us about this a bit?
I do not know whether I should go into details of the matter, because
CJ can advise.
Yes, the CJ can advise. But
Well, do you want me to advise now before you explain, or do you want to explain?
Can I say something before
Okay.
you?
All right.
All right. All I can say is, unless the CJ says I must say more. All I can say is that, remember, I had the benefit of hearing the evidence, of seeing all those who were there, who testified before me. I applied my mind and I did what I thought was the correct thing to do under the circumstances. take into consideration demeanor, what they were saying, as well as the pre-sentence reports. However, I respect the comments made by the judge, and I appreciate what he has said about it, because I realize that I might have erred, but it is still going on appeal. I might have erred, yes, and that is how we magistrates learn. We send our matters for review, or they take us on appeal. The comments made by the judges in our cases, be it good or bad, helps us to improve. There will be cases where you will be commended on what you have done. There will be cases where they say, no, you have misdirected yourself, you have erred. But that doesn't make you a bad magistrate. It doesn't make you a very good magistrate. We learn from the comments that they are making. But for that case, yes, I applied my mind to it after I had about 5 witnesses. I had the opportunity to observe them, and I was of the view that the only way of doing this is by imposing this type of a sentence. It was in 2012, and those comments were made in 2014. It is an unprecedented sentence, as you can see, and I expected the state to appeal immediately, but it didn't. So my guess was that because they were also there, they are of the view that that was the only thing to be done under those circumstances.
CJ, I'll leave it to you if there's anything else on that matter. Thank you.
Very well. I take it that you are done. Thank you. Minister?
But CJ, maybe quickly, just to check a procedural point, that since she said this matter is going on appeal, those languages of yours, is it not what? Sub judice. Because we might be tempted, we must be guided by you, CJ, that if it's still a matter that is pending, we must shy away from it, because we might be tempted to go into the merits of the case, and I don't know, we'll be advised. Because the matter is still pending.
Well, it's a tricky situation, and I'll tell you why. It was a publicized matter. It was in the legal brief and other publications. Some of us know the facts. Now the question is, she having mentioned it in her questionnaire, and others having read about it, is it best to afford her the opportunity to say something before this commission, so that nobody gains the impression that she lacks judgment or judges her prejudicially? Or is it best to be overly technical and say, no, an appeal has since been lodged, let's say nothing? And then people will remember what they read in the media and say, wholly suspended sentence for attempted murder, where a stone was used on the head of a woman and tore her ear. 2 incidents of rape on the same day. Even if you're the former boyfriend, is it right to suspend the sentence wholly? Do you afford her the opportunity to respond, or do you say, no, don't touch it? But remember, people know what happened. And when they vote, what happens? So that's the choice that she has to make. Minister?
In fact, I was going to add, I think you've stolen all the words. Well, a judge can't steal. I wholly agree with you, Chief Justice, that unless we are given the opportunity in our minds, subconsciously, even if we try to ignore this, it will linger. So I think it's better that unless she objects, and so on. Can I just check, though, in that vein, you've been a regional court magistrate since when?
Since 2004.
So I would imagine that over a decade later, your experience at that level should be of some significance in terms of dealing especially with criminal matters, given the fact that the matter in question was a criminal matter.
I agree, Minister.
Now, it so happens that this is the one controversy that is before us, but are you concerned that you may, along the way, in your practice as a magistrate, in your career as a magistrate, have not perhaps been able to acquire sufficient judgment skills to be able to execute your function as a judicial officer as efficiently as you could, given a controversial matter of this nature?
I cannot say that because, as I say, I have been in a sexual offences court for since 2004. And I have dealt with many, over 1,000 or two of sexual offences involving very young children, teenagers, adults, elderly people of 100 years. And if I may, I don't know whether you can allow me to say so, because on Thursday when I was leaving the office to prepare to come here, the stenographer, we use stenographers as clerks of the court as well. My stenographer brought me my appeal register. And he said to me, "Madam, is it possible for you to take this register with you as an exhibit?" And the reason why he was saying this is because since 2004 up to today, and remember that in the past our cases were sent to the High Court for sentence, and thereafter we were given jurisdiction to sentence. Since that time, when I checked that register, I think I have only 2 cases which were set aside. Most of them were confirmed, and those who were tampered with were those of, only the sentences were interfered with. And in most cases, it will be sentences of life imprisonment. Most of them were altered to between 20 and 25 years. So as far as experience is concerned, I don't see myself being not experienced enough. Hence, I say this was a unique case, if I may label it that way. It was a unique case. Its circumstances, I hope you have, I believe you have read the case. I tried to go this way. I thought about a heavy sentence, but the conclusion kept on driving me to the sentence that I have imposed. I can say that when the complainant was testifying, giving her evidence in chief, all I could see was life imprisonment. While she was still testifying in chief, I could see nothing but life imprisonment until she was cross-examined, until other witnesses testified, until a pre-sentence report was brought before me. And I just, like the Chief Justice says, maybe I must shed more light on it, because it
but you nonetheless did arrive at a conviction.
Yes.
Oh,
I beg yours?
so- No,
Conviction, yes, there is no way I could have acquitted. The facts were glaringly in that direction. He was
that you
guilty.
must secure a conviction.
I beg yours?
The facts were such that you had no choice but to arrive at a conviction.
No, as far as conviction was concerned, there was no other way. He was
But having
guilty.
reached that point,
Yes.
the kind of sentence you could think of that would be fairest in the circumstances
Yes.
was as is described.
Yes, Minister. Because if I may maybe elaborate on that,
Yes.
The,
Trying to understand.
The complainant, I'm not trying to rewrite my sentence because I respect the Honorable Acting Judge, but the facts were that, that is how I understood them. The facts were that the complainant and the accused were each married to separate people. They had a love relationship. They were working together at Sun City. At some stage, the accused decided to leave Sun City to go to Legend. And the complainant followed him to Legend. The complainant testified that she was very close to the accused's wife. The accused's wife was confiding in her regarding her marital problems, until she realized that she is confiding in a wrong person. She became depressed. It is there in the victim impact report. She became very much depressed. She got divorced from the husband, and the children were left in the care of their father and their grandmother. She even went to the extent that they love me. His children love me. They call me Mama. I was looking after them. I was taking care of them. I was cooking for them. I was doing their washing. So the evidence is such that their relationship was characterized by violence coming from both sides, the accused as well as the complainant. And and the complainant was also attacking her colleagues whom she regarded as being close to the accused. One of their colleagues even laid criminal charges against her. There was evidence that he once struck the accused with an object on the head. 3 days before the commission of the offense, the accused obtained a domestic violence order against the complainant. And now I looked at it this way, that both of them involved themselves in that kind of a violent relationship. But that relationship led to a situation where the children do not enjoy the motherly love because of depression. And again, it led to a situation where I had to think about them at that stage. It was very, very difficult, because I said, if she is telling me that she became the mother to those children, and now that the situation is as it was at that stage, what it means is that she will no longer go back to them and take care of them. The relationship was over, I think. That is how I looked at it. Now, if I sent the accused to jail, what will happen of those children? There are situations where you say, no, I hear you in mitigation. I hear you are saying you are having very young children, but I'm giving an example in other cases that came before me. You want me to look at you with mercy because you have young children, but you are the author of your own misfortune. I don't even think your children, your own children, are safe with you. But in this case, I just thought that they were, I think, between 6 and 17 years of age. Accused will go to jail. Their mother is a depressed somebody. They don't even want to be with her. They are staying with they will remain behind with their 75-year-old sickly grandmother. Now, I likened that with primary caregiving. And I said, when I was assessing what type of sentence to impose, I said, the decisions of the Constitutional Courts and the Supreme Court of Appeal with regard to primary caregiving deals much more with a person who is with those children on a daily basis, who bathes them, prepares their lunch boxes, come back to them at after school, prepare food for them, and so forth. And in this case, their father is a breadwinner. He is not a primary caregiver. But now the object or the interest that we think of protecting is the interest of the children, and they are the same whether you are a breadwinner or whether you are a primary caregiver. And again, I will give an example by myself. Yes, I go home every
Chief Justice, if I may. Yes. The impression I'm getting is that I get a sense of where you're getting, but I am not convinced that it's really assisting us in doing justice to doing a proper assessment of whether there was a reasonable, ground to believe that you may not have misdirected yourself in your sense of judgment, given all the circumstances that you have just outlined.
Yes.
I mean, for example, there are systems in place in terms of our social welfare system, such as foster care placement and other alternatives at state cost to intervene in circumstances of similar nature. So far, unless there's something completely exceptional that explains your thought process there, speaking for myself, I am still not finding any direction that says there could have been a uniquely exceptional situation in this instance. But I leave it to other colleagues to do their own assessment.
If I may, that is what I said when I started. I considered that after those comments, and when I rethink the matter, I now believed that I have erred, I have misdirected myself. I said I considered from the beginning.
All right.
I talked about.
The last point I wanted to check with you relates to civil exposure. You've been in the regional court as long as you've described earlier. The regional court has only acquired civil jurisdiction only recently. So it is not conceivable that perhaps until your acting stint, and perhaps for the short duration that civil jurisdiction had been introduced in the regional court, that you would have had much civil exposure. Now, to what extent is that likely to be a factor in limiting your ability to be an all-round judge if you were to be appointed on a full-time basis to the bench and having to be confronted with a variety of civil work?
In the district court, we were doing civil matters as well. And also when I was a senior magistrate at Seshego, I did mostly civil work. And then in the High Court, I was also given civil matters to attend to. And I even discussed this with JP, and I said to him that that was in January. I said to him that I've been doing criminal matters a lot. I dealt with many different kinds of criminal cases, and I think acting will benefit me if I am given a civil stint, if I may say so. So he indeed agreed with me that with criminal matters he doesn't have a problem, and he extended my acting stint and gave me another term, which was only civil, with few appeals, criminal appeals that I did with another judge. I wrote several judgments during that period, and I am satisfied that I can handle
Thank you,
civil
Chief
matters in the
Justice.
High Court.
Thank you, Minister. Doctor?
Mrs. Semenya, you know, you said you started practicing 85. And I know that is a time when there was a state of emergency declared, which lasted until about 1989. And that was a very difficult period. During that period, I knew senior magistrates like Ratlavala, Manyana, Makwela. They used to come to me asking for advice, wanting to quit the system because it was very difficult. I'm just amazed how a young woman like yourself managed to live through that period, and that even today, except this incident, there's nothing that one is hearing of, that you didn't discharge your duties well, that you are not equal to the task. You know, as lawyers, we have what we call errors of judgment, errors of law, and that's why there are systems of appeals. But what I pick up about you makes me wonder why lawyers are not forced to take behavioral sciences, because it comes across that your Butu came to play here. You were not just looking at technical rules, that this is the minimum sentence.
Doctor, in view of what I said, and we agreed to, just put a question to her, please.
Yeah. So the question is, thank you for your intervention. The question I was coming to is, were you influenced by the human face that the law should have, and the fact that the best interest of the children should be put first in these circumstances?
Both of them played a role, because I had to attend to those two aspects as well. The interest of the children, where do they go? And also, as you have just said, if you can, because of what you said, I believe that you have read the record.
I just want to say that you come through to me as an honest person, because you disclose the matter. You accept that in hindsight, you made a mistake. So honesty is a very important point, and thank you for making yourself available.
Thank you, Commissioner.
Commissioner Modise.
Thank you, CJ. Good afternoon, Ms. Semenya.
Good afternoon, Commissioner.
I see you were born in Kwatema Springs,
Yes.
and that, in fact, you would come from my generation, which means that you would be one of those young women who were, one, not very socialized to stay at home. You went to university, you studied the laws, and therefore you would be up to it on the issues of gender and issues of women specifically.
I agree, Commissioner.
So you would also, being somebody who comes from Bukwatema, the Ekurulen area, you would be aware that the victim in such circumstances always gets the blame.
Yes, sometimes yes. That is the reason why sexual offences court were created in the first place. Yes.
Thank you, ma'am.
Just to sensitize people that when you deal with the sexual offences court, you deal with cases where girls will be raped simply because they are at a tavern at a given time. So what we do in our judgment, you say, yes, They are the citizens of this country. They are entitled to be anywhere, anytime. So you cannot say because she was at the wrong place, then the accused cannot be found guilty. Whether she was drunk or not, the thing is she is not there to be raped. Why are boys allowed to be in the taverns at any time, but when it comes to girls, they are not supposed to be there?
There will be follow-up if she's not satisfied with your answer, ma'am.
Are we, women citizens of South Africa, being unfair to expect the courts to be more sensitive to exactly the points you are raising?
No, you are not. You are not at all.
And in your experience, because being one of the women citizens of South Africa, I have been having my doubts about the enforcement of the Sexual Offences Act. Do you find it easy to enforce?
Yes, I find it easy to enforce. Yes.
Easy?
Yes, the Sexual Offences Act.
Yes.
You know, one good thing about the Sexual Offences Act is that it covers almost everything. It deals with trafficking, it deals with different kinds of rape. Remember in the past, I studied in the 80s, rape was rape as it was defined then. It's not the same as it is defined now. Because in the past, men took an advantage that if I penetrate my finger, I won't be found guilty of rape. So as it is, it covers everything. And it covers both the situation as it was in common law, and it took it further.
No, ke a leboga, Ma'am Semenya. The reason I was putting this to you as a practitioner is that most of us women in South Africa have heard stories of how difficult it is to implement this act. Now, you say you don't have a problem at all. May I just ask you my last question? Why do you think you are ready to become a judge?
I went through many stages of a judicial office.
I'm aware of that, but what would make you a good judge?
I listen. I listen to the parties. I sit down, I apply my mind. I, most of the time, do not just jump to conclusions. I write, when I do judgments, I write and rewrite until I say, yes, this can go out. As well as the fact that, as the JP has said, we need women on the bench as well. And I am qualified and experienced enough to become one.
Well, I was a bit impressed, and then I became very worried when you said you come home at 4, you take an hour and you start writing you didn't just say notes. You said then you start drafting your judgments. I was a bit worried whether all cases were similar and that all of them required, just an overnight writing period.
They are not the same, but remember, if you are in the sexual offences court, all you do is sexual offences.
No, ma'am. When you were speaking, right at the beginning, you referred to how busy you have been when you were acting, and how in the regional court you went to work from 9 to 4, took a rest of an hour, and then started drafting. And you did not make a distinction of the different matters that you had. You just said then you start writing because you do not want to lag behind.
No, I come from an era where we were not recording mechanically. We were taking notes. So I still continue to do that. When we are busy with the matter, I just write almost everything that is being said. And when I go home with those notes.
Okay.
And when I write the judgment based on the notes that I am having. And most of the time they are thorough. Otherwise, if you don't do that, you will be overwhelmed because you will have 20 pending judgments to write.
I'm going to leave it there.
Thank you, Chairperson. Advocate Ngozi Thomas.
Thank you, Chief Justice. Good afternoon, Madam.
Good afternoon, Commissioner.
You said that this case came across as a unique one. So in legalese, basically what you're telling us is that you found compelling and substantial circumstances that warranted deviation from the prescribed minimum sentence. Is that what you're telling us?
Yes.
Was that recorded in the judgment?
I did not write them like item 1 is this, item 2 is this, item 3 is this.
I guess my question is, did you say, I convict for this offense, and ordinarily this is a sentence that I should impose, all things being equal, but now because this case is unique, in other words, because I have found substantial and compelling circumstances in this specific matter, I am deviating from the minimum prescribed sentence, and these are the substantial and compelling circumstances that I have found that on the basis of which I'm deviating. Did that come across clearly from your judgment?
I did not, I do not remember. I don't think I did that. I just wrote a sentence and gave reasons why I am arriving at this conclusion.
Is it not expected of a judicial officer to set it out in the manner in which I have suggested?
The Act says you must do so. You must state that because of these circumstances, 1, 2, 3, 4, I wrote of the reasons that I gave as substantial and compelling was the interest of the children.
Now, how long you had been presiding in the criminal court for how long before prior to this judgment, Ms. Semenya? I mean, with your experience, I guess I must just put it to you that one would have expected slightly more. Am I being unfair to you?
Yes, I agree.
Yes.
I just considered from the beginning.
No,
that,
if if one were to suggest to you that it might perhaps be a good idea to give yourself a bit more time, act a little bit more, so that you're very comfortable on issues such as this, would you say that is an unfair comment?
I would say so.
Why?
Because that will, as I say, I regarded it as one of those unique. I've done many cases, rape cases, and I say I forwarded them to the judges for appeal. They went there for appeal, and 99.9% of them were confirmed. And it is just that some of my sentences were reduced from life to 25, which is still a fairly long period. I'm comfortable with that. But I did what you are saying, it is expected of a judicial officer. Where there were substantial and compelling circumstances, I would do so. Where I could not find any, I was imposing that sentence that is prescribed in the in Act 105 of 1997. But unfortunately, some of them were reduced to there are those where I imposed life, which were confirmed.
Ma'am, please, if you could just confine yourself to the question, it would help. You have told us that. Please.
Thank you.
I add in this matter by not stating. I add by not stating them.
Thank you. Thanks, Ms. Semenya. Thank you, Chief Justice.
Thank you, Commissioner. Commissioner Nzebeza?
CJ, it seems to me that there have now been two concessions made by the Honorable Magistrate as to how she acted, and those were the things I was going to test.
Thank you, Commissioner Nzebeza. Commissioner Kabashi?
Thank you, Chief Justice. On the same points, ma'am, the Constitution, and I just want short answers. You are comfortable that you can deal with the Bill of Rights in any court? You are quite comfortable.
Your mic is off, ma. Please switch it
Your
on.
mic?
Your mic?
Yes. And you are comfortable about that, not only in relation to the criminal law, but in relation to the civil law as well, and the rest?
Yes, I am.
You are quite comfortable that you understand the role, the duties, the powers of the three branches of government, and you know exactly, or you can read up on, if you have to, what you might have to do should you be faced with circumstances where you're taking a decision on some infraction or the other?
Yes, I.
And you are happy with the Chapter 9 institutions, what they do? I mean, we don't know everything, but you are comfortable that you've had sufficient exposure to what those institutions do, where to find the law, how to consult your colleagues on the bench, should you need assistance with anything?
Yes, I am.
Thank you very much. Thank you, CJ.
Thank you, Advocate Kabashi. JP?
Thank you very much, Chief Justice. Good afternoon, Ms. Semenya.
Good afternoon, JP.
Me and you were at varsity together.
Yes.
We finished together. Chief Justice,
They are
am I
laughing
protected?
at me because you are a judge president. I'm still a magistrate.
Thank Miss
I think
Miss
that's why
Semenya.
commissioners are laughing at me.
Colleagues, please.
I want to confirm, I invited you to come and act in the division. You were recommended to me, and I have had no occasion to sit down with you and find fault with anything you've done. But I just want to deal with two aspects that you've said. You said working in the regional court and in the district court prepared you for the high court.
Yes, JP.
Do I understand you to be saying you found no difference in terms of conceptual nature, volume, complexity in the work of the high court and the work you've done?
I do not want to lie. There is a difference and you need to adapt. And I found that in the High Court, you procrastinate at your own peril. Because you'll be given files of cases to do, and you will think that these are the matters that I have been called upon to come and do in the High Court.
So you found, I'm sorry to...
Okay.
I'm actually saving you. You know, if you were my witness, I would have said, just answer the question.
Yes, I found a lot of difference,
Yeah.
and you need to adapt some way.
Because you see, the reason I'm asking is, and that's why I'm toning down in terms of inviting magistrates to come and act. Because there's a view in the magistracy that says you deal with the same law as judges, therefore it's easy work. Do you come from that school of thought?
But not at all. You are saying I'm a bedwetter. You know, you in the magistrate's court, you deal with the case right from the onset. You start with the evidence right from the beginning. And you write to a judgment based on what you have. But in the High Court, remember that there are appeals. It is decisions made by another person. You must read those decisions and you must be able to put yourself in the boots of the person who was presiding over the trial and make sure that you understand this case from that person's perspective.
Okay, let me ask you a different question, slightly different based on what you're saying. You had occasion when you sat in the High Court in Pretoria to sit on appeal in judgments written by regional court magistrates.
Yes, JP.
You did.
Yes, correct, JP.
And did you find any areas where they went astray?
Most of the, yes, the issue, the most part that I have realized was the application of cautionary rule. Most of them miss it.
Okay. So you see, I just want to make sure I understand you because I don't want to support you, yet I'm supporting someone who come to the High Court and be a problem. Because we have those instances. Your JP can confirm that. He knows.
It won't be the same. It can't be the same. There are good magistrates.
Okay. Let's leave it at that. Let me come to this case. This case where you sentenced, you see, I'm a bit constrained, CJ, because when Ms. Semenya says she erred, I don't know whether I can ask her that by saying that, does she say she now realizes she should have imposed a harsher sentence? I don't know if I can ask that because this matter is on appeal. You said you concede, you erred. Are you saying, looking at this matter now and having thought about it, you should have imposed a harsher sentence?
But on a procedural point, CJ, I'm worried. I'm worried because if the matter is on appeal, I don't know anything. I'm not a lawyer. And the matter is on appeal, and she's going to make certain concessions here. Whoever is appealing that matter can even take this before the court and say, I don't know what we're still doing here because she has already admitted.
Well, no, it doesn't work that way. It doesn't work that way. Appeals are dealt with purely on the basis of the record. And remember at the beginning, I said it's for her to decide how far she wants us to go with the matter. She can decide to say, no, sub judice. Or to say, you know, people are beginning to suspect things that are wrong about me. I want to put this matter in a proper perspective. And that does not happen without questions being put to her. And by elaborating on her own in the manner that she did, she therefore allows commissioners to put clarificatory questions to her. So the JP is well within his rights.
Ms. Semenya, you remember the question I asked?
I'd rather leave it to the appeal court.
Okay, that's fair. One last question. Do you, I suppose when you were researching and writing this judgment and the sentence, you must have looked at other cases.
Yes, I did.
Did you look at the case called State versus Nkomo from the SCA?
I didn't even cite it in my judgment. I didn't.
But did you look at it? Or you don't remember looking at it?
I don't remember.
This is because if I'm not mistaken, your case, it was more than one rape, isn't it?
Yes, it was more, the evidence presented was that of more than one penetration.
So it was a life sentence case. Now, in State versus Nkomo, the facts are not similar, but the SCA reversed the life sentence to 16 years. And there was an outcry in this country against that judgment. It was written by Justice Cameron and Lewis, but Justice Theron dissented.
Oh yeah, I know the case, yes.
Did you consult it when you wrote this one?
Yes, I did.
No, okay.
Justice Theron dissented in that matter.
Yes.
I didn't find it applicable in the matter before me.
Yes. Thank you very much, CJ. In fact, just before I step off, I confirm that when you acted in the High Court, you acted in a number of difficult work areas like the opposed motion court, the unopposed motion court. You confirm that?
I confirm that.
Thank you. Thank you, CJ.
Thank you.
Commissioner Malema?
No, thanks very much, CJ. Do you know Judge Masipa?
There are two Judge Masipas.
The one who handled Oscar's case.
Yes, I know her.
You know she made certain rulings there?
Yes.
And then they were overturned by the appeals court?
Yes, I know.
That's the appeals court overturning of a judgment makes her of a lesser judge.
No, not at all.
Did you lose any respect for her since the overturning of that judgment?
No, I didn't. She's
What?
a judge. She applied her mind to the matter.
So, what is the purpose of the appeals court?
It is to look at the judgment. If it needs to be corrected, it will correct it.
And that's how judges are held accountable when they've erred.
Yes.
And your case that we refer to is not different to many other cases which were there, which were appealed. And the appeals court ruled against very senior judicial officers.
I agreed, Commissioner.
But also that you have 2 reported cases.
I do, Commissioner.
And there are so many so-called senior judges without a single reported case. Is that true?
I agreed, Commissioner.
Thank you very much.
One last thing. Is it fair to assume that as you consider what was in the best interest of the children, you also took into account the interest of the victim?
Yes, I did.
And it's reflected in the judgment?
Yes.
Okay. Thank you. You are excused, ma'am.
Thank you, Commissioner.